Would a shareholders agreement do the job, maybe even in a more cost-effective way? But at the same time, are there certain things that can only be done by altering your articles of association? In this video, we will discuss whether altering your articles of association is the best option compared to simply drafting a shareholders agreement. If you're new, let me very quickly introduce myself. I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Gaffney Zoppi, my law firm. And on YouTube, my goal is to make business law easy. Make sure to stay until the end of the video to find out how to properly alter your articles of association. But before we get started, let's very quickly define what are articles of association. In short, they are the bylaws of a company, the rules for how to run that company. They tell directors and shareholders how to manage decisions. Great, now we will, number one, outline the advantages, and number two, the disadvantages of choosing a shareholders agreement over altering your articles of association. The shareholders agreement advantages is that, number one, it is confidential. So the shareholders agreement is not published on Companies House and is kept within the shareholders. On the other hand, articles of association are publicly accessible via Companies House. Secondly, usually a shareholders agreement is less costly to produce from a legal fees perspective than amending your articles of association. The reason being is that when amending or altering your articles, there are a few documents that need to be produced, not just the amended or bespoke articles of association. This is because you need to follow a specific corporate procedure to comply with the Companies Act, which we'll get to in just a few seconds. And lastly, a bespoke shareholders agreement can, for example, state that you only need more than 50% of the shareholders to be in agreement to amend that shareholders agreement. Instead, when it comes to altering the articles again in the future, you will typically need at least 75% of the shareholders, or if doing a poll vote, which is when you vote according to the amount of shares that have the right to vote, then at least 75% of the voting shares need to be in favor of that new alteration. Great, now let's move on to the disadvantages of using a shareholders agreement over altering your articles. Firstly, if you want new shareholders that later joined your company to agree to the shareholders agreement, they need to sign typically a deed of adherence. So that means that they physically need to sign something, whether physically or electronically. Instead, when it comes to the articles, anyone new that joins the company, whether a shareholder or a director, is automatically bound by those articles of association. The second disadvantage is that the shareholders agreement might conflict with the articles of association. Now, if that is the case, then typically the articles of association take precedence over the shareholders agreement. So it is best practice that whilst drafting your shareholders agreement, you need to cross-check the articles to make sure that there is no conflict. And if it turns out that there is a conflict, then you should go and alter your articles nonetheless. Which brings us back to square one, which means you're spending legal fees on both a shareholders agreement and now also having to alter your articles of association. And the last disadvantage is that the shareholders agreement does not bind directors. That is because the shareholders agreement is, as the name implies, an agreement between the shareholders. And not always is a director also a shareholder. There could be two different people. Instead, when it comes to the articles of association, they bind everyone in the company, both shareholders and directors. Amazing. Now, before we move on to finding out what are the procedural legal requirements when altering your articles, make sure to subscribe to the channel to continue to receive to-the-point, practical and pragmatic legal information and templates. Also, if you would like some professional legal advice from a qualified solicitor on amending or altering your articles, make sure to reach out. I have my contact details below. Although I have already linked below a step-by-step guide that tells you exactly how to alter your articles, I'm going to very quickly give you an overview of the process. Number one, you need to have a board meeting. That is, the directors of the company need to come together and approve the alterations to the articles. Second, you will need to send the new articles of association in their amended form to the shareholders, and they need to vote on that. You will need a special majority or a special resolution to be able to pass that decision, which means at least 75% of the shareholders, or as a poll vote, at least 75% of the voting shares. And lastly, you will need to submit documents at Companies House, including the special resolution of the shareholders and the amended Articles of Association. Also, if you're going to sign the special resolution via electronic signatures as a written resolution, then make sure to remove the signature trail that is produced by the software typically and found at the very bottom of the document. Make sure to remove that before you submit the documents at Companies House, because Companies House will reject your special resolution if you have that signature trail at the end of the document. If you want to see a step-by-step walkthrough of exactly how to alter your articles and access templates, make sure to watch this video right here. Thank you for watching.